Well, good morning, everybody. Good morning. I'm Paul Ahern. I'm one of the partners here at the firm. I believe we've got everybody who's coming tonight. Excuse me. But I want to acknowledge that we have some bright lights and a microphone up here and a guy videotaping us in the background. And that's because we have now started to tape all of our client events so that we could put them on the website. For those of you who participated in our client satisfaction survey last quarter, we want to thank you. One of the comments that we heard was that we can often make your educational workshops, but we would like to know what is being said. Can you help us out? So as a result of that, we are taping these and they will be posted on our website probably within 2 or 3 weeks after an event like this. We just have some compliance and editing to go through, and then it'll be up there. I'd like to get started today. I believe I have some of my colleagues. Mike, was there anybody else out there?
Don, you want to step in?
Okay. Mike Bowen and Don Bertrand are two of our financial planners here in Scottsdale. Most of you are aware that when you work with us as a firm, you really have hired 13 different individuals. A lot of them you know from your interaction when you come in here on a personal basis. But these are two of our advisors who sit on our portfolio committee. So every investment in your portfolio, these two have a voice in what gets put in there and when changes are made. So we're going to let them go today because I'm going to focus on our other two colleagues that we work very closely with. Thank you, guys. And that's David Colby and Megan Thorns. They are estate planning attorneys. They work for the law offices of Colby and Thorns, which is just on the other side of this wall. How many of you in this room have done your estate planning with Colby and Thorns? Could I see by a raise of hands? Okay, quite a few of you. Then you know. And for those who have not done your estate planning with them, perhaps you've met them in the past because we often ask them to come into our meetings to sit down with our clients to review how assets are titled, how their beneficiaries are set up. If you're a business owner, do you have some issues there? If you have family issues, are there some problems there that they might be able to help you out with? So they are a huge, valuable resource to us as a firm. And today, they're probably going to be the biggest value to us and our clients on a topic that we've never discussed openly like this. Over the last 15 years of this firm, we've done a variety of different workshops. Most of them have covered the gamut of wealth management, tax planning, and estate planning. But never have we done a workshop specifically on the topic of how to prepare for the death of a loved one. But what we have found over the years is that when somebody passes away, we tend to be asked the same questions from family to family. So it occurred to us, why not do an educational workshop specifically focused on addressing some of these very questions? And I'm going to ask Megan in a moment to even give us a real-life example. Unfortunately, our firm is all too familiar with what needs to happen. And what we have found is that when somebody passes away, the client's financial planner and or estate attorney are two of the first people called when we get into the professional or business side of transferring of assets. So I will tell you that from our standpoint, when a client of mine passes away, I usually bring in David and Megan at that very next meeting because there's a lot of work to be done. And oftentimes I will bring in a CPA as well. My job as a wealth manager and everybody at WealthTrust-Arizona is to coordinate who needs to be involved and to make sure that you have everything you need to go through this process without having to add anxiety to grief, because we will do the work for you. But one of the things we hope to accomplish today is how to do a lot of work in advance. And you have some information that we're going to reference from time to time. But the one thing I want to point out is this survivor's journal in particular is going to be the guide to help you get all of your assets in order and make sure that your loved ones know where things are at, where passwords are kept, etc. So you will hear David and Megan refer to this periodically throughout this presentation, but this is maybe, in my opinion, the most valuable thing we've ever handed out to our clients in the 15-year history of this firm. So what I'd like to do is turn it over to even Megan to give a real-life example, and I believe David is going to start. But we had a real-life case just last year.
Sure. This client was kind of the inspiration for these seminars because her husband had been providing for her and the family for his entire life, and she was quite capable of obviously doing all those things herself, but he handled the finances and he handled the estate planning and he took care of all those things for her, and he passed away unexpectedly at a time when she was going through some major medical issues. She was having some major surgery, And she came in and she sat down and she really didn't know where to start. And she said, I know I can do everything. I went to college and my major was organizational management.
Yep.
She's extremely organized and capable, but she didn't even know where to find the tax return. She didn't know where to find the tax documents. She didn't know where to find anything. She didn't know which, she was frantic. She was scared. Can I still use my credit card? All these things that you know, you do so secondhand and so second natured every day. They were just major concerns for her. So we sat down and we realized as we were helping her walk through this maze and helping her kind of organize and get all the passwords together and, you know, finding out which bank accounts had automatic debits and which didn't and which had automatic deposits, that this would be a helpful thing for all of our clients to do, because not only does oftentimes one spouse in the family take care of all the details like that, but when second death occurs, children are stepping in, and it can be even more difficult then. So this client was kind of the inspiration for these seminars and for these survivors' journals, which we hope you guys will find useful and that your family finds useful.
If I could just, while I was wrong that story, the kicker of the whole thing, and I remember her well, was that they had children from different marriages they were on, and the second marriage, and they had a blended family. And his children, one of his children, because of the urging of the spouse, started writing her nasty letters about their estate and what's in it for them. And this was right at the time when, about a month after it passed. So it was, to say it was an emotional experience for her. It was difficult, and it just made us realize that there are so many different scenarios here. And what we want to do, and I have allergies, it's a bad season for me, so I'm not contagious, but it's, you know, I suffer between now and the end of April, I guess. So forgive me. So what I want to talk about now is, we're going to talk about some basic stuff. You know, this subject matter is very large, and it's not possible to cover everything in the time allotted. So we try to cover what we think is important. And if you have any questions at the end, because we don't think we covered something that's of interest to you, please feel free to chime in. You know, the first thing we talk about is organize and communicate. This is really crucial. Notice we're talking about both spouses on meeting the advisors, stress testing your financial and your estate plan, both spouses understanding the budget, both spouses understanding the cash flow. Maybe it is the case in your household, maybe not. You know, households do division of labor. My wife and I do divisions of labor, and sometimes we look at it and say, isn't that your job? So, but we do that all the time. You divide and conquer. Life's busy. But this is one of those things where even if you do have division of labor here, we don't want the surviving spouse sitting and asking the question I've heard a million times. What would he or she have done? Let us know what he or she would have done, because you need to communicate that's to each other. So part of this is just a confidence of knowing what direction to go and whether the direction you're on is the direction you should stay on. So it's very important that this all be done. We're going to do a little stress testing of your estate plan here today. Not big time, but minor. This journal is very nice because it allows you to collect the information that you need. It's basic housekeeping stuff. It's dry, but it's important. We recommend that you collect all this data. And the funeral stuff is also important. Some people really aren't ready for this. You want to think about this. If you have children that you feel it's time to share this stuff with, we find that when families do first death preparation and implementation, when you have trusted children in the room for the surviving spouse, it makes it so much better on every level. So we encourage that if it is all possible in your circumstances. This organization process is, Megan, I want you to step in on this because we're partners. You can see a huge age difference here. I'm the old guy who's been doing this forever, and she's young and IT savvy and does all these things and brought me up to the 21st century in every fashion in our practice. So a lot of what we do is we share information, we divide and conquer in our practice, and Megan is dots every I, crosses every T. So when it comes to collecting the records and doing all this stuff and helping the spouses do this, she's pretty much involved in implementation, so why don't you take that over?
Sure, and a lot of our clients, when we finalize estate planning documents, they always ask, where should I keep this? Where should I keep these documents? And it's, you know, I think it's important to have everything in one place, safety deposit boxes aren't necessarily a great place to keep important records. They're safe places, but they're hard to get into when something happens to you because you're not there anymore. So we've been through experiences with clients where you spend months writing letters back and forth to the bank and getting the probate court to send, paperwork allowing us to open a safety deposit box to find nothing in it. So although safety deposit boxes are great safe places, a lot of our clients should have a safe at their house, or have an office, maybe a waterproof, fireproof file where they keep all of their important documents, and all the important documents are in one place. When something happens, the kids can come and pick up that box and they know they have everything. They're not sorting through file cabinets and 8 different places.
And as a part of that process, what we do as part of the IT 21st century, she brought my practice into when we became partners, is we're completely automated and everything's paperless. We have everything, we scan everything in. We can help you when we collect your files and help you put together your plans to help you automate, put this stuff on scanning, put it in systems so that your stuff isn't loose paper going around. Because if you put it on hard disk and then you back it up, it's a much better way to handle your documents and your information than anything else. The way we do documents now, for example, when we sign documents at the table, we immediately go scan them into the system. And if you lose your originals, we have a chain of custody from the signature to the scanning. This is something we've done the last few years with Megan's expertise. So we encourage people on financial records, on basic records, and we're here to help you do that if you're a client of ours, we will help you collect this stuff, scan it in for you, create digital files. And if you create digital files, it becomes so much easier later to get your finger on everything.
And then the next 2 topics are our filing system and phone and mail system. And these start now, these filing systems and phone and mail systems, but they're really extremely important when death occurs, because if you've ever had anyone close die, you know that the one thing that starts happening immediately is phone and mail. You start receiving mail from life insurance companies, from pension companies, from all sorts of people you never thought you'd hear of, and they all want 4 or 5 different documents, and please return in the enclosed envelope, or please fax this. Or you get phone calls and they say, well, I need this, this, and this, and I need you to follow up. And all of a sudden you've got 5 things going, and you didn't remember who you sent what to, and maybe they were the ones that called back and requested something else, and it's hard to sort it all out and keep it all in line. So we encourage people when a death does occur, get a new notebook, put it by the phone, list everyone who calls, what your response to them was. If you responded back to them, write that down. If you sent them documentation, you can pull out that notebook once a week, look back and say, hey, I haven't heard from this company in a week, let's follow up with them. But these organizing and filing systems and phone systems, particularly with the mail, when you send stuff out, you always want to keep copies of documents you've sent out, because inevitably they come back, well, we didn't get that, or it wasn't filled out completely, and then you have to wait another 2 weeks for them to send the form back out because you sent them back the original and you didn't keep a copy of it. So these are kind of minute details, but they're so important to helping you keep track of things and making it easier on you, because the mail does start immediately, the phone calls do start immediately, and it's a stressful time in anyone's life. So to be on top of all that at the same time is expecting too much of ourselves, I think. Finally, the Survivor's Journal does provide, if you look through the journal, one of the nice things about it is it sits down and it writes down information which you may feel like you know and your spouse knows and your children know, but when it comes time to fill out a death certificate and they go, oh, what was Grandma's maiden name, or what was, where was she? I think she was born in Cleveland, but maybe it was a small suburb. Those sorts of information that you don't want to be running home and looking through filing cabinets just to confirm you have the right information. So the Survivor's Journal is meant to provide, you carry it with you and it has everything in it and you don't have to think about it twice. Also, the Survivor's Journal is extremely important for you to notate sorts of things like accounts. If you have all of your accounts at one place, you won't believe how much stress that'll take off the survivor and the children, because having all your accounts consolidated makes life 10 times easier. But for clients who do keep accounts at different institutions, having a list of where those accounts are, having a list of who you would contact to deal with those accounts, and identifying any websites that you use to log on to those accounts and the passwords associated with them is extremely crucial, because you guys know if you go to log on to an account that you've been on and you get kicked out, you feel like you don't know what's going on with your accounts and your money, and you're like, oh my goodness, what? And then you have to call the institution and have them reset the password or go through additional steps to find out you just had the password wrong, and it just adds additional complexity.
You should, and passwords, this is a big problem, and it's becoming a bigger problem. And you and your spouse need to be on the same page about what your passwords are going to be. My wife and I do. We use the same passwords. We know what the passwords are. We use the same passwords because we know that if we don't, there's no way I'm going to get in. We know what the username is. We know what the password is. We use the same password and we use our different username, obviously. And this applies to all your accounts. Everything's so digitized now that if you aren't on the same, you don't need to write it down if you both know. Because it can put a roadblock on our end when we don't know how to get into the information and we're not sure what's in there. And remember, at the time the surviving spouse is dealing with this, you're in a period of grief. This is not the time to be dealing with this stuff. So you want to get it out of the way now and get you and your spouse on the same page in this stuff. So later, it's automatic.
Right, and particularly because nowadays every institution has, you have to have one capital letter, and maybe one additional letter, or one
they're
extra
different.
character.
This one's got this one, and this one's got this one, and you find out yourself having 3 or 4 different passwords, just simply the way you open these accounts, but you haven't necessarily shared them all with your spouse and consolidated it. That does come up in our world, and we're powerless because we couldn't know what the passwords are. If you can't get in, we certainly can't.
Right, and plus a lot of times when you reset passwords, they send it to an email address. And if you don't have access to that email address, then it doesn't do much good to get a reset password. Finally, about memorials and funeral services. And I want to just touch on this briefly because funeral directors and, or if you're doing cremation, a director at a crematorium can be extremely useful. There are a lot of steps involved when you're trying to go through the process of determining burial. If you're getting buried in another state, if you're transferring a body or an ashes to another state, there are all sorts of issues that need to be dealt with, and funeral directors are extremely helpful in this area. They will take documentation down, they'll prepare obituaries, publish them, they will help coordinate memorial services, they'll do all these sorts of things that you didn't think about, but you expect to happen, because most burials happen within 3 days of death, and that's a short period of time to start thinking about, my goodness, when, what time, and someone call the restaurant, see if they're available. And on that same note, it's a very difficult time to start looking and saying, oh goodness, well, would he wanted a military, would he wanted a military burial or a church burial? These are all issues that you'll go through, and having that knowledge up front, having those decisions made up front can be extremely helpful. If you want someone to do a reading, if you have special passages you like, if you have special music you like, you don't have to dictate everything that you want, but these are helpful hints for your spouse, or more importantly for children, so that they know when they're planning a service how far they should go, or how little, what exactly you wanted, what you would want to memorialize your life. So these are sorts of things that you would put in maybe a letter to your children, just letting them know your wishes and your desires. And you'd be surprised at how many clients, one spouse wants, I want a nice service, the other says, I don't want anything, I want the kids to go on a trip. Or I want them to spread my ashes here, and the spouse is going, really? I never thought about that. So these are things, if you just can get on the same page, at least have them written down so that the children or your spouse know, it saves those 3 days of grief thinking about and wondering, well, did I do the right thing? Did I do what they would have wanted?
And by the way, you don't have to do any of that if you don't want to. The way you do your estate plan, the way we do all estate plans, and the executor of the estate plan would be the surviving spouse. And as the executor, you have complete authority and ability to deal with any funeral objector, and you don't need anything in writing to do so as executor, so you have that power standing alone. What I want to do now is, by the way, as we go through this, I'm going to move into some legal stuff now, because when we try to implement first death issues and second death issues, the nature of your written plan controls what we do and how we do it. So there are generalizations, but what you're going to find going through the next hour is, depending if you have a trust, whether you use wills or whether you don't have anything at all, will determine what we do and how we do it. There's a million pieces of paper in all this. Part of what Colby & Thorns does, if we're hired, is we do every piece of paper. We don't ask clients to outside of funeral arrangements, we pretty much handle everything else. We are happy to not handle anything our clients don't want us to handle. But usually at that time, they don't want to fool with this stuff at all. So let's talk about the possibilities. You can die either with written instructions or without them. Pretty simple. If you have written instructions, you either have a trust or you have a will. Now, everybody has a pour over will with a trust. I'm not talking about that. You have a trust with pour over wills, or you'll just have a will. And I'm sure no one in this room has no written instructions. I want to mention this for one simple reason, in case you have children in this category. If you die without written instructions, in Arizona, you die in what's called intestate. Arizona statute, in fact, writes a will for you. That's fine. But the question is, does that will that they wrote for you work? It leaves everything to the surviving spouse. Except if you've got children, or if any of you in this room have kids from different marriages and mixed marriages, and you die without a written instrument, the surviving spouse does not get all the assets, even if you've been married 30 years. Pretty much, roughly, without getting into the details, a quarter of those assets will go to the children for the previous marriage, of the other spouse, the deceased spouse, their children. Now, I can imagine a situation like this, and I just point this out in case you know kids or grandkids in this category. People get divorced, they get remarried, he's got 2 kids, she's got 1, and the kids are underage. One of these young people prematurely dies, the estate doesn't go to all the surviving spouse, part of it goes to the children from of the predeceased, or the deceased spouse, right? They're underage kids, who gets that and those assets? The ex-spouse of the person you married who died. So if you got kids in these categories, just get on the internet, go to a stationery store, do a simple will, leaving everything to each other. Don't rely on this. Once that happens, we can't fix it. We're duty bound to notify those children of the deceased spouse that they have a property right to this estate. This is not a fun time to be in. So if you have kids in that category, just give them a what's up to just go get an internet will. Now, I'm going to have Megan go over this, but I want to explain probate for a second. We're going to talk about when do you have to go to probate. Nobody wants to go. We know we want to avoid it because we've heard about it not being a good thing. What is it? Let me just define it, and then I'll give the clicker to Megan. Probate is a process that is required if you die with something in your own name. Now let me explain it to you. Let's assume, well, how do we know? How do I transfer an asset? A car, title to a house, bank accounts, I sign my name. We can't get my signature if I'm dead. Now how does it work? So what is a probate? A probate is a process whereby the court literally signs on behalf of the decedent, so we know who gets it. Let me reverse it. Let's assume that you want to buy a car that I put in the auto trader. And you come test drive it, drive around the block, and I want $14,000 cash. You think it's a good deal and you're ready to buy it. You come up to buy the car from me, I whip a title out and I say, oh, by the way, it's in my wife's name alone. And she died, I'll just sign for her. Are you going to buy that car from me? All of a sudden you don't want to give me that cashier's check. So think of probate as a process required, otherwise the bona fide purchaser for value isn't going to touch your account. You can't transfer anything. You couldn't get a house transferred, you couldn't get anything done. So probate is a process that's required to clean title because I can't get your signature or can't get my signature because I'm dead. There are ways that you can, there are ways you can avoid that process. Forgot to turn it off this morning. This thing rings all the time. So there are ways you can avoid that process, and we'll talk about those here with Megan. But probate is required if you have an asset in your name when you die. Trusts and things like that obviously avoid probate. Why? Because if you own a trust and the asset's held in the name of the trust, when one of the beneficiaries, when one of the trustors, when one of the creators or trustors or trustees dies, the trust didn't die, so it can transfer inside the internal document without needing to change the signature so you can avoid probate. So why do I mention that to you? Think about those assets that might be sitting out there that you've missed. Because if you missed an asset, we might have to go to probate. So Megan, talk about the possibilities and what we do there.
Sure. If you have a trust, a revocable trust, and you transfer all your assets into that trust, meaning you retitled them, so you've retitled your bank accounts, you've retitled your vehicles, real property, brokerage accounts, those assets will pass by way of your trust. There's no probate involved in that process. If you have a trust and you leave assets out of the trust, you may trigger a probate. And in Arizona, there is a probate exemption limit. They call it a small estate limit. And what Arizona statutes say is that if you have everything passing either by beneficiary designation or passing through your trust or passing by some way that happens automatically on death, then you can pass another $50,000 that is in your name. So you can say you have a bank account for $20,000 and a vehicle that's worth $10,000. You can pass that by a small estate affidavit, which is a document you sign under oath saying that you guarantee the value of these assets are less than $50,000, and you sign that document and you submit it to the motor vehicle department, or you submit it to the whoever holds the bank account, and they will turn title over to whoever the executor of your estate is, the trustee of your trust.
Now, that's not per asset, that's total
2,000
asset.
cumulative.
So this is why we routinely tell clients, unless you're buying your automobiles at Barrett-Jackson, you don't need to put your autos in your trust. Because the general value of those autos on death, even if both your names aren't on them, are going to be less than 50. So if most of your assets are in your trust and you got a couple of automobiles not in your trust and their total value is under 50, you'll pass them by affidavit. Believe me, we can get any affidavit passed in the probate court on any used car below 50. We all know which way they go. They don't go up, and therefore it doesn't matter. Even really nice Lexuses drop substantially fast. So the reason why we also tell people not to put these in your trust is because you have a hard time selling them through Auto Trader or whatever if it's named in your trust, because no one's going to buy it because they don't understand what you just did. You have title to the car, the name of the trust, and I go to transfer to you as the buyer, and I see here's my trust document. You're going to go, well, I don't understand that stuff. So you're going to lose buyers. So we don't think it's a good idea. And there are exceptions to that, but that's the general rule. So anything you miss less than 50, if it's a total value is less than 50, you get it in and out of the affidavit for what, $250?
Yeah, the most common example for our clients is a lot of our clients choose to leave their cars in joint names with both spouses, and they may leave a bank account out of their trust. And typically on first death, when the first spouse passes away, that's when we sit down and we say, all right, let's put that remaining bank account in the trust, and let's get that vehicle now in the name of the trust so the kids don't have any issue later. But that's a typical scenario for our clients, leaving one bank account and vehicles out of the trust. Now, there's other ways that you can pass assets by operation of law other than your revocable trust. Obviously, your revocable trust, anything that's in that trust passes on your death by way of the successor trustee, so no administration, no probate's necessary. We've also got IRAs passed by beneficiary designation, 401ks, life insurance passes by beneficiary designation, annuities as well. There are also account settings that you can use. If you go to the bank and you didn't have a trust account, so say you have a daughter and she's married and she doesn't have any kids and she doesn't have an estate plan, she has her account set up with her husband and she has it set up as joint tenants with right of survivorship, or community property with right of survivorship, or even transfer on death. The bank accounts will use these designations to automatically transfer assets on a person's death. So for example, we had a client's child who passed away, and that child had a payable on death provision on their bank account that automatically paid the assets over to a sibling. That avoids probate, and it allows them to have kind of their own estate plan without having the complexity of going through the probate process.
I want to add one last thing here on this horrible recognizing probate. We've had situations where you'll have a trust, and for whatever reason, a substantial asset wasn't put in, and it's large. Even if you own a trust and you leave an asset out that's above $50,000 in Arizona, the pour over will says, I hereby leave my assets to my trust on my death in my name. So even in that situation, a pour over will minimize the probate. We literally open the probate up, we transfer the asset to the trust, and we close the probate. We can actually get your probate open and closed on a pour over will with a bona fide trust in 4 months. And it's really not expensive. You know, Arizona doesn't charge statutory fees for probates. It's an hourly rate thing. It's not like some of these Byzantine things in New York or Illinois or back east. So, you know, you can get through this. So even if you miss a substantial asset, it's really not a large deal to get it probated. If, on the other hand, all you have is a will, you're going to stay in probate, and you don't have trust, you're going to stay in probate till the last asset is distributed to the last beneficiary. Whatever that is. Now you can imagine a situation on second death, or if you're single and you have a will, and you have real property you're trying to sell in this market and distribute the cash to your children. How long can that take? So One of the dilemmas about this market right now is real estate not cooperating. And so what we have to do is be mindful of that when we put our estate plan together, because sometimes we'll find there's holding periods for that estate plan, for that real estate, that's longer than any of us would ever want it to be. One last thing on this pour of a will. If you own real property in states other than Arizona, and you did not put that property into the trust, our pour over will still works, but we got to go to that state to do the probate. We can't do it here. You have a condo in Illinois outside of Chicago on the lakefront. You have wherever, Wisconsin lakefront property that you like to visit in the summer, and that property is not in the name of your trust. Our pour over will applies. We will then ship that pour over will to a lawyer in Wisconsin, who will then open a probate, transfer that asset to our trust, and then we'll proceed to administer it from here. But you'll be paying that Wisconsin lawyer for that privilege. And that's going to be a lot more money. We can get probates done here under a couple grand. We're not expensive because we have, but you go out of state and want to hire somebody, Mr. Sweat, you know how this works.
Yes,
They want a premium. They don't know you. They know they're never getting a piece of business from you again. It's a one-time shot. They tend to overcharge. And they want the money up front in a retainer. So, do yourself a favor. Do not let properties outside of Arizona languish outside of a trust. If you have a piece of property in Arizona that's not in the trust, no big deal. The portable will get it done. We have it here. We can get it transferred here. We can open and close the probate here. It's not going to cost an arm and a leg. Okay? Now, I want to shift gears here now and talk about this passed by operation of law. It's wonderful if you can pass stuff by operation of law and you never have to use a lawyer. Great. But don't step over dollars to pick up pennies. When we plan estates and we do this stuff for our clients, we're not trying to avoid probate or minimize some small fees. We're worried about the IRS. I want to tell you the most important thing to us, the thing that we worry about the most, and it comes home to you when these things visit us, is the IRS. So none of these simple plans solve your problems with the IRS. So unfortunately, the estate gets complicated simply because the IRS is complicated lives. So if there's one theme I want to leave you here with, is the IRS is not getting friendlier, and we'll talk about that in a little bit. So part of the proactive nature of our estate planning now going forward, preparing for death, is this moving target of the IRS. I'll bring up a little bit that detail. And if it sounds like I have a chip on my shoulder about these guys, it's very large. I don't like them at all. And I don't want to hide that. Now let's talk about beneficiary designations. They avoid probate. And they're great. And most people leave all your assets to your surviving spouse. That's fine. If you have small IRAs, if you have small rollover plans, that's great. But the larger the assets that you have, there are qualified dollars. Those dollars that you put in, and you got tax benefits for putting them in, and they grow tax deferred while you're during retirement, and then when you're 70 and a half, they make you pull retirement distribution out. At 59 and a half, you can start pulling out without penalty. You pay applicable tax on what you pull out, right? All sound familiar? Some of our clients have very large plans that they've rolled into IRAs, or maybe not yet. There's a wide variety of these employer-sponsored plans. They're wonderful vehicles for accumulation for retirement. They are the worst vehicle in the world for passing assets to the next generation because they're so subject to taxes. So they're terrible vehicles for planning. So I would rather be left $1 million outright than $3 million in an IRA because the taxes are brutal. They're subject to both income taxes and estate taxes, both. Now why do I bring this up to you guys? Because if you have large IRAs, you want to make sure that you have lawyers who know what they're doing looking at the beneficiary designations so that you don't walk past tax problems. Because if there's something, and I know we're preparing for the death of a loved one, but the last thing the surviving spouse or the children want to hear is, whoops, we got a tax problem here we could have avoided. Now, if you're a good lawyer and you know what you're doing, you realize that you can't afford to screw your client's estate up if it's large because you're in the middle of it. So for us, this is serious business. When you go to the surviving spouse, that's great. But I'm going to show you in a minute why sometimes that doesn't work. Maybe you want to go to your children. Let me give you a simple example of how this, you go to your broker. Now, if you're working with us in Wealth Trust, you know, we do them right here. You go to your broker, and you've got this large IRA, you rolled it over, and he or she is really happy to manage your money, and they pull out the standard little form, they put the surviving spouse in as the beneficiary. And sometimes I go further than that. I can tell you stories. Now, one example of the obvious problem. Both of you live long lives, and you beat the curve, and you're way out there, it's great, and the first spouse dies, and the survivor review's 88, 86. Now, as soon as the surviving spouse takes that asset, the surviving spouse has to RMD it based on their age, 88. Well, if the life expectancy in the IRS tables is 94, they're going to take out 1/6 a year. Well, and they don't need it. And the government's getting the tax, you're putting the difference in the account, and you're going backwards. You would rather leave it to the children. What we do here, there are so many scenarios, I can't give them all to you here. But on large IRAs, we pull out our toolkit. If in a large IRA, what we want to do is the surviving spouse needs to have the right to disclaim all or a portion of that IRA directly to the children. Why? Because if I disclaim it to them, they can use their measuring life instead of mine. If I'm 88 when I receive it from my surviving spouse, ooh, RMD is ugly. If I bypass that IRA, disclaim it to my children because the beneficiary designation lets me do it, my children now then get to use it, and if they're in their 50s, 60s, they've got a 30-year measuring life and not a 5. Is that difference valuable? At the tax rates now we're charging that don't seem to... How many of you think in the next 5, 10 years your tax rates for moderately wealthy people are going to go down? Yeah. You know, you're getting a feel of it, aren't you? Yeah, it's coming our way, isn't it? Yeah. So what we want to do is we need to take advantage of every little nook and cranny they give us because they're not generous with us. So we can't leave anything on the table. One of the other things is, so we want to be able to, we don't want to leave, you know, we don't want to leave the IRAs to the children if the spouse needs them. So you can leave it to the surviving spouse with the option that within 9 months of the first death, the surviving spouse can disclaim all or a portion of the IRA. Now this isn't self-help stuff, guys. You don't just go scribble this down on 3 words or less. You're dealing with the IRS here. It's like, I got a 10-year-old daughter. I got married late in life, married a younger woman. I got a 10-year-old daughter. She doesn't get credit for the answer. She gets credit for showing her work. The IRS ain't no different. So they're a gotcha game with these guys, and if they ever bother to look, you will actually think they're trying to say, oh, it's okay. I know, but you tried. They want the I's dotted and the T's crossed, and if they're not, it's a gotcha game with these guys. And I'm kind of fed up with them, okay? Because they're not getting any nicer. So you want to make sure you get that right. If you are ever going to put an IRA in a trust, for any reason, and there's some darn good reasons I'll talk about in a little bit, do not do it yourself. Do not do it with a broker. As fine a money manager as this guy is, he knows to ship it over to us. It's lawyer stuff. When we put IRAs into trust and do this, Megan, how long is our beneficiary designation form for a large IRA?
About 10 pages.
Oh, these lawyers complicated everything. I'm just trying to keep up with the IRS. I feel like with these guys, I'm one nostril above the waterline. They're making changes to the regs constantly. We're trying to keep up with these guys because we feel our high net worth clients are at risk. Okay? So this is very important to do right. So never do these yourself. Incorrectly drafted beneficiary designations can result in an accelerated payment of income taxes. And remember this one last point. Your IRAs, if they're large, are also part of your estate for estate taxes. It's a double tax. So we really got to think this through carefully. Okay? Now, I'm going to give it back to Megan, and this is about what we're going to do after death regardless, whether you have a trust or just using wills. We're going to go through the things you got to do regardless, and then we'll step after that, and I'm going to talk some details about trusts and the things that apply just to trust that you may or may not be aware of when death occurs. But I'm going to hand it over to Megan now, who's going to talk about no matter what kind of plan you have in writing, the following things we have to do regardless.
One of the first questions, and probably the biggest complaint we always get, is why do I need so many death certificates? We suggest you get at least 10 death certificates, one or at least one per account. So the more accounts you have, the more death certificates you need, because everyone wants an original. Any county in which you own real property, they will want an original death certificate. Any brokerage house, each individual investment may want a separate death certificate. And it's easier to get them up front when you're getting them from the funeral director than to have us go back to the vital services office and reorder them months later.
And we're saying at least 10.
Right.
So if you have a lot of different accounts, double it.
Exactly.
They're not that expensive, and they'll save you time and money later.
Well, one of the next things that we always do, every estate, no matter how it's calculated, no matter what sort of plan you have, you will always need to get date of death values for all of your assets. That includes real property, brokerage accounts, automobiles. And the reason for this is because the IRS calculates your estate as of the value on the date of death. In addition, Arizona is a community property state, and on the date of first death, every asset that you own gets a stepped up basis as of the value on the date of death. So if you had that brokerage account, you took it from $500,000 to $1 million over the last 15, 20 years, good investing, and that brokerage account's now worth $1 million, we want to get values on every asset in that brokerage account. So if you decide you want to change your portfolio the day after your spouse dies, you can do that without any income tax consequences. In addition, if the IRS looks back in 20 years and says, well, wait a minute, I think that estate was a lot larger than you said it was, you can go back and show, we have a record. We got the date of death values. We got certified appraisals for real property. And Estate Val is a company that is used by the IRS to get date of death valuations, and we use that company to get valuations for all QSIPs. So for all
That also
accounts.
includes any asset, we call it cash, mark-to-market. Any assets to mark-to-market. What's mark-to-market mean? Cash assets or any securities, stocks, bonds, or real, is mark-to-market. Because you can look at the stock or the bond market and it tells you today what it's worth if you sold it. That's the date of death value on the date of death. But real estate obviously has to be appraised. Limited partnerships have to be appraised, or whatever mechanisms they use if there's one inside them. Timeshares have to be appraised. You have to get appraisals of anything. Now, the problem you have is if you don't get an appraisal of an asset, and later the IRS asks a question about it, and you don't have an appraisal, the IRS gets to ascribe the value it wants, give you a deficiency notice, now the burden's on you to prove they're wrong. So when we collect first date of death valuations for property, we're creating an audit file. Not because we think you're going to get audited, because we want to be ready if you do. Because if they audit the estate, they can certainly do it on first death, but many times the audits don't occur until second death, and that's when the children are facing your estate issues. They don't want an audit. So you can actually see that if you don't collect the date of death values right on first death, and second death occurs and it was never done, you can see if you got to go back and try to recreate values from years earlier, it's a little rough. So date of death values on first death should be done, and you should start conducting those within 3 months of first death. We do that stuff here for our clients because we're building the audit trail and hoping they never look.
Sure. Filing life insurance claims. If you do have life insurance, that's one of the first things. They'll need a death certificate, and you also always want to collect what's called Form 712 from the insurance company. That is something that calculates the date of death value for that insurance policy for the IRS. It's something that the IRS will want, and it's something that if you don't request it when you file a life insurance claim, you do have to go back and get it, and it can be more difficult to go back and get later.
Let me just say something on the insurance claim. It relates to this. The insurance companies aren't going to contact you. If you don't ask for the money, they're never going to notify you that they owe you money. And then the amount of insurance policies that sheet to the state after 7 years of unclaimed will really surprise you. And you've heard these things where these people say, oh, we'll find money for you. This money goes unfound. Because we can only file a 712 requesting the company pay the death benefit if we have proof of the policy and you've recorded it. And if you haven't done that, and that happens a lot of times, these little tiny policies, 3 or 4 of them, and they're X number of years old. So you want to make sure that you collect that stuff as part of your survivor's journal and put that stuff together so that if you hire a lawyer, they can get the 712 and go after it for you.
And if any of your accounts or even credit cards sometimes have life insurance policies associated with them, you want to keep track of all those and just make a little record, because they may be little policies, but they all add Implementing beneficiary designations. When death occurs, we want to make sure that we actually get the IRA transferred over or get the annuity rolled over to the new beneficiary. And we also at that time have to sit down and determine who's the next set of beneficiaries. You always have to update that because you would be surprised at the amount of people who don't put contingent beneficiaries on their IRAs or their annuities.
And you see how that's a problem if the surviving spouse is 88, we don't have good contingent beneficiaries put in place, we can't disclaim it to the children. And now we're stuck with a surviving spouse having an RMD that's accelerated and we're all stuck. And if you have no contingent beneficiaries and you disclaim it, all the IRS says all the taxes are due within 5 years of an IRA. I'm not trying to get you to understand the Byzantine world of IRA regulations, only to remind you if you have a large IRA, they're Byzantine regulations. Remember that, have them reviewed, make sure good lawyers draft your beneficiary designation with taxes in mind.
Was there a question?
Yeah, so if the surviving spouse, so if the spouse who's passed leaves a contingent beneficiary besides the primary, can the surviving spouse change the contingent beneficiary? Is it locked in?
It's locked in.
It's locked in. But if the spouse rolls over the IRA, so if they accept the asset, so they roll it over into their own name, then they can create their own new beneficiary.
But by rolling it over their own name, they've started RMD at their age, so, you know.
Which has a cost.
And then the new beneficiary designation isn't the basis for your disclaimer. It's the one that's the original. So you can't roll it over and do a new beneficiary designation to do an end run around your disclaimer problem. It won't work.
Right, and then finally, one area that's often overlooked, and it can happen a lot when there's deaths, when minor children are involved, is applying for benefits. Obviously, you may have government or survivors benefits. There are also benefits for minors if you have children who pass away prematurely. So applying for government benefits is one of those things that a funeral director can also help you with, and that when you come into the office here, we can always help you look for, determine which benefits you're eligible for, and apply for those. Make sure you get the money.
And there's sometimes veterans benefits too on funerals and burials and stuff, and so you want to if you're a veteran, you want to pay attention to that stuff because there are significant benefits sometimes that go with that, depending on what service you were in and what your stature, what level you were in the military.
Right. And I want to go back to, I don't think I mentioned notify Social Security immediately. That is one of the most important things. If you're getting Social Security benefits, those pay automatically into your bank account, and as soon as the IRS finds out of the death, they're going to go back and sweep that account. So if you get checks, you want to make sure the IRS is the first person, Social Security Administration is the first person that you notify, because they will come back and take that money because it's paid up front for the month, and that's not a position you want to be in. I have seen clients who had that money put in an account, they're paying a funeral bill with it, and all of a sudden it gets swept back out and they're paying overdraft fees.
Or, you know, the Social Security check is going into an account, it's a joint account, and if there's an issue that they think that they paid out an insurance and Social Security check after date of death and they shouldn't have, they'll go sweep the account and ask questions later. So you got to be really careful how you do that. So, and you know, we help people walk through that with regard to that. So they'll actually sweep money that has nothing to do with the Social Security benefit. Yeah, government's great.
And so the phone and mail systems come into play a lot with these when you're whether it's getting your date of death valuations or applying for benefits or filing insurance claims, having all that information recorded in one spot, knowing who you talk to, that makes those systems really important if you start those immediately.
So these are the sort of things we pay attention to immediately when we're doing this. Okay, you know, I'm going to go over this quickly because we just talked about it and I want to get to the meat of something important. If you just do a will alone and you don't have any trust, you're going to be in probate until the last asset's distributed to the last beneficiary, and you're going to be, all of it's going to be a matter of public record. How long that probate will stay open will depend on how long it takes you to dispose of all the assets and distribute them.
Right.
So it's not an efficient mechanism, it's not an inexpensive mechanism, and here in Arizona, we strongly advise against them.
And all those date of death valuations that we get on assets have to be submitted to the court and submitted to all beneficiaries of the estate. So those pleadings will go around and be submitted to all the beneficiaries.
You know, the West is the leader in reform of the law, but in the old days, particularly back in the Midwest and the East, in the old days, it was common. Lawyers would give the wills away because when it got to the probate, you're mine. And that's where they make all their money. So, it's a different process out here in the West, and it's migrating back towards the East, where the idea is to create really good comprehensive documents and avoid this entire process. So we know how to do this. She's an expert at it, but we don't think our clients should want to go through it. I want to now switch to what is really going to be significant. And I'm going to start here with the basic trust, which is the revocable trust that divides the estate on first death into two trusts. Most of you who have a trust have one of these. You don't all have one of those, and we'll talk about it in a minute, but most of you have this. There are a set of rules that go with this on first death that we want to talk about. This isn't just on paper. There is an actual lot of first death implementation as a result of this AB trust, and we'll talk about it. And the most important reason why we do the AB trust, and you all probably have heard this before, I want to remind you one more time, it bears repeating, is because of the IRS. Now, what do we know? Let's talk about the exemptions. Each of you has a state tax exemption. That's the amount as a U.S. citizen that you can pass free from this god-awful tax. You all have one. One of the problems is when you die, your exemption dies with you. So what we do is we preserve the exemption of the first to die, then we grab the exemption of the second to die, so when the children get the estate, they get a double exempt amount. They get the exemption from the first to die, the exemption from the second. And that's why lawyers do these documents. It's strictly IRS. Okay? Any questions on that? Because it's really important. Because we know here are the exemptions. They went from 675 to 3.5. We had this repeal, 5, 1. Now, here's what's interesting. And if it sounds like to you that I'm beating up on Congress, I apologize. But I do this for a living. In 212 is an election year. I mean, does it get more political than that? And we're going to expect them to fix this in 212? Or are we going to default to this in 213? I don't know. You can decide for yourself what you think is going to happen. I have my opinion. As a lawyer, I'm frustrated because they didn't really do much to do a fix, did they? No. They didn't do a fix. But they're going to go save us all, right? When we're doing estate planning and we're doing it first death administration, it doesn't pay to have a lawyer who's optimistic. Whoops, I missed him. Sorry, I really thought the wind was at your back. We always have to plan and think about this stuff with the idea that they're going to try to confiscate your money. Now, if they don't, great. We planned for it, they didn't take it. I own my house outright. I still buy fire insurance. It's a premium I pay every year. I can't afford that risk. So when I talk to you about the things we do in your estate at this level and the complexity of first death planning, remember why we're doing it. We're doing it so that we can grab the exemption of the first to die, we can grab the exemption of the second to die, so that we can preserve the double exemption. So if you can imagine having an estate worth $4 million, and let's say the exemption is only $1 million. I put $2 million here and $2 million here, right? Half and half. Each of you owns half your estate. How do you know that? Go get divorced. You only own half. So the half of the survivor doesn't go anywhere. You still own it. The half of the first to die goes in the decedent trust instead of to the survivor, so we can preserve that darn exemption. So imagine on a $4 million estate, if it was $1 million exemption per person, one here, we'd put 2 and 2. Then we'd preserve the double exemption, which is $2 million, and you'd have a tax on $2 million. And the tax on $2 million at 50% is $500,000, right? Imagine if I didn't do that, and we went from $4 million to $1 million, then to the kids. Now we have a tax on $3 million. Now our tax is $1.5 million instead of $500,000. Now, what are these exemptions going to be going forward? You can handicap it yourself. We're worried they won't be generous. And we do all our planning with that worry in mind. So when I talk to you about the complications of this and what this means on first death, remember what's at stake. The difference between a $500,000 tax and $1.5 million tax to your kids. You've got to preserve the exemption of the first to die because you can't afford not to, because you don't know where this crazy quote's going. But one thing I want you to realize is, because you get a lot of optimism, people read a funny little article and they feel like they're safe. The OMB, the Office of Management Budget, requires, it's part of federal law, it's good law really, that when you pass a tax legislation, that's tax cut or whatever, you gotta show the cost to the taxpayer of that. So if they kick a $5 million exemption for 15 years or 10 or 20, they've got to publish with OMB the amount of money that it costs the taxpayer to do that. That's why they're kicking the cans at short time periods. Because if you do it for a long time period, then you got to expose that. Okay, is that good or bad? I'm not trying to turn into this a class of politics, but I'd be stupid as a state. I'm a tax lawyer. If I didn't pay, Wisconsin means something to me as a tax lawyer. I look at that and say, okay, I see something coming around the corner here. So we're going to ask people to give up Social Security and Medicare. And we're going to float really high exemptions. It could happen. It could happen. You can believe whatever you want. But I'm a lawyer, I'm a realist, I'm glasses half empty. I can't afford to look at the kids in the eye and go, oh, Dave, you missed it. Well, shucks, I was just hoping for the best. So you got to run through this. Now, this becomes a fairly complex administration. But you know what? The savings to your children are huge. You get no benefit from this. I've told you this before, and I want to remind you. On first death, you have what's called the unlimited marital deduction. You can die with no estate plan at all. You can be Bill Gates, and he can leave all of his money to Melinda. She doesn't owe a penny of tax on first death because the IRS on the federal level says if you have a bona fide marriage from any of the 50 states and you pass those assets to the surviving spouse, there is no estate tax. It's a free pass go. You're good to go. But what you did is you gave up the exemption of the first to die in that process. The kids pay for it, not the surviving spouse. No matter what lawyers have told you, if they said to the contrary, you don't need this. Your kids need you to have this. That difference is really important. So one last time, your kids are pulling you through a keyhole. I have a 10-year-old, so forgive me. Yeah, I'm still cleaning up. I still, walk over stuff barefoot and get creamed, right? You know that one, don't you? So you're doing this for them. Now, what happens on first death is Megan and I sit in the room with you with a financial planner. Now, when you're doing this, what you're going to do is you're going to put half the assets in this trust, half in this trust. You're going to get a tax identification number for this trust. We're going to literally put half the assets here, transfer title. This isn't some paper deal. We're going to put half the assets in this trust, transfer title, into the name of that trust, or the survivor can keep it in their own name. Either way works. This goes into the decedent account. And then we're going to do all the data values, and we're going to file what's called a 706 estate tax return. Now, when you file that thing, you put all the appraisals, you put everything in it, and what you're trying to do when you do this estate tax return is you're trying to put it together at a very high level. So you want to say to the government, move on, there's nothing to see here. You go in on that, you try to be don't pinch pennies here, use pros. Because the IRS has to decide who to audit. And they don't tell us what they decide. But I'm a firm believer, after all the years I've been a lawyer, is the quality of what you submit to them makes them make decisions. It would for you too. Lousy work versus good work, right? So the 706 is we file here, and we go in boxes. This is the enemy. This is the enemy. And so what we do is we put all this together for them, and then what happens is, as you remember from your trust, the survivor of you is going to live then with two trusts. Now, you also know that if the decedent's half is greater than the exemption, we're going to spill a third trust called that marital trust. So you're going to have either 2 or 3 of these. And then the survivor is going to live with these trusts, so we're going to implement this. And the hand-holding that comes is very important. When you're doing your first death administration here, this is going to have some fees too, the CPA fees. 706s can cost a few bucks. You do all this, but it pales in comparison to the savings to the children. And the survivor you has to then deal with this. What we do here in this office is we sit down with the law firm, CPAs, financial planner. We're all in the same room together, getting this all done for the surviving spouse for them. We don't ask them to do any of this. We do all the implementation for them. So that we're setting this up. We file the 706, and we then realize that the IRS probably won't look at this estate till second death, if they ever look. Okay? Now, one last thing I want to mention to you here when we go through this on first death is Remember earlier I talked about large IRAs. Let me give you an example. We put half the assets here, half here, because you each own half. Let's say I got a $4 million estate. And let's assume 2.5 of its IRAs or 3. We have some very large qualified plans. Because of the nature of their work, they got all of their stuff qualified. If I have 4 million and only 1 million of it is non-qualified, I'm putting 500 here, 500 here. If I pass the whole IRA in a simple beneficiary designation of the surviving spouse in an IRA, I've overfunded this and underfunded that. If you have large IRAs and you don't pay attention to your beneficiary designations with competent lawyers, you can underfund the decedent trust depending on the size of your IRA in relation to your total assets. The other thing that you can mess up is you do a joint survivor deed, so all the real estate goes to the survivor. Your deeds should pass to the trust so we can divide them on first death. Even though the decedent has an exemption, we got to fund the trust to capture it. And if you put too much over here and not enough over here, the kids are going to end up with more tax than they could have, because what we do before the first of you dies, dotting the I's, cross the T's, depending on the nature of the estate, can determine whether this thing is funded properly. It's all connected. And once death occurs, if we have too much flowing over here because the people weren't paying attention to the lawyers, it's not your fault, it's their fault. And this is overfunded and that's underfunded. But how would this be overfunded? IRAs or joint survivor deeds on real property, overfunding this side, underfunding that side, leaving the kids with a tax on second death that they wouldn't have had to pay. And what are those taxes? 45 to 55%. And that's why we always want to stress test our plans to make sure that our IRA beneficiary designations, our real property, and all of our, we get everything so that as much as possible. How would we do the IRAs? We leave it all a surviving spouse with the ability to have cascading disclaimers to trusts or people. Is it complicated? Of course it is. Does it work with the IRS? Absolutely it works. Because we might have to disclaim a portion of an IRA to the decedent trust to fund this. I've actually seen clients in their mid-80s with IRAs passing over here, underfunding this. We were triggered R&D, and we have a second tax. I mean, I don't expect you to understand my world, but I want to leave you with a feeling that if you want to plan your estate properly, don't think that large IRAs don't matter in planning. They shouldn't just go to the surviving spouse. That's why we do the 10-page one, because you can actually leave IRAs to a trust and do it right. It's possible. The rules do let you do it. They're just kind of long beneficiary designation forms, okay? And then the second one is the simple administration of a trust. Boom, no split. All goes survivor. No 706, no lawyers, no CPAs, you're home free. What's the problem with this one? You're not preserving the exemption of the first to die, right? There's a little, now, what happens if you're in this crazy little netherworld where I'm not sure if my assets are going to be above or below the single exempt amount? Which way should I go? Should I do the more complex one or should I do this? It's a legitimate question for a lot of people. Here's what you can do, a little practice tip. You can do what's called a disclaimer trust, which allows us to go all this survivor by default. The survivor within 9 months of the first death can disclaim into a second trust a portion of the assets up to the exemption of the first to die. It starts looking just like this one, only it's done after death instead of before death. Here we default to complexity. Here we default to simplicity with an option to complexity. You get to the same place in sheltering assets for the children, it's done differently. This is for the trust with disclaimer for those clients who may be close to a single exempt amount and you're not really sure. If you're not sure where you are on that stuff, that's why we have reviews. The day where you can take your estate plan, put it in a shelf, and not look at it for 20 years are over. Because the IRS is moving faster than that. So we always have to make sure. We like to talk to our clients every year, every 2 years. Now, when tax law changes occur, we shoot a letter out to you. And if you're our client, you've seen them. But we still want you to come in because we want to make sure we're up to date. Because having your plan work when the first loved one dies requires it continually be stress tested because we're worried about the IRS. So here's our options, you know. This is the most expensive and complicated way. This is more minimal complication, simplest, but this one you can default to, you can use a disclaimer trust to create this second trust. So those are your three options. So our clients are down to this one or this one, and we're constantly trying to figure out which is the right one. It's a $5 million exemption per person now. If extended for a long time period at 5, I'd plan differently. Since it's going to 213 back to 1, that puts more people in this category. You see where I'm going with this? Okay. Last thing, and then we're out of time. Children. You know, there's two loved ones in this scenario. There's the first spouse to die and the second spouse to die. And remember, I told you that the only reason why we're doing these complex trusts is to benefit the kids. You don't need them. What we want, and if you are a client of ours, you know this, you can leave your assets outright to your kids. And that's fine as long as you're not leaving them a lot of money. But if you're leaving them a lot of money, Arizona law, it was codified in the Uniform Trust Code in January of 2009, you can make trusts for your children. They can be trustees of their own trusts. It's like being a sole member of an LLC. They have a conversation with the mayor to manage it and get it out. But they have an umbrella from creditors and an umbrella from divorce. Are those things important? Only if it hits them. Is it going to hit them? I'll leave that for you to handicap. I think if there's one thing that's a theme of how we manage estates here is we hand out umbrellas. We don't predict the weather. I can't know where the IRS is going to go. I don't know where your kids are going to think. So what we do is try to hand out tax umbrellas for you and your children, and creditor protection umbrellas and divorce protection umbrellas, because we don't know when trouble's going to hit. But I can say this with a generalization. Trouble does follow money. And the more money there is, there's more reason to lawyer up to fight. Okay? And the last thing I'll bring to you so you think about it is, even if divorce or creditors aren't your issue with your kids, the other reason why we like to put trust together is on death that tells you where it goes. Imagine I have two daughters. Imagine my daughter gets married, the second of me and my spouse dies, we leave her $1.5 million. And it's a righteous marriage. We even like him better than her. We think, you know, we're congratulating her parents for doing a better job. His. Then, but my daughter dies 2 years after she receives her inheritance. And then he isn't going to live alone for the rest of his life. He gets remarried. And the woman he marries has got 2 kids in tow. Where's that money going that you left? I don't know. You don't know either. So does it matter? It only matters if you're passing significant assets. If you're not, it doesn't. What's significant? How many zeros are required? That's for you to decide. But what I'm leaving you with us on second death is we can protect your children. Now, when death occurs, it's really important, if you have a functional family, that the surviving spouse and the children sit down in the room together and go over everything. And that's the time when we explain to the children, if we've done it right, the protections we've given them. Now, we don't allow spouses in the room. It's you, the survivor of you, and your children are the only people in that room, so we can speak candidly. And one last thing, and I wanted to bring this out to you because this is real-world experience. Some of you are going to leave some substantial sums to your children, and some of these children have never seen that kind of money. It's like winning a lottery. And you really don't think about what that means because you don't feel like you should think about it. Why? There's a myriad of issues here, not the least of which is my father dies, I'm left $1.5 million, my marriage is so-so, and I get home after meeting the lawyer, and what's the first thing she asks me?
How much did we get?
How much did we get?
Cha-ching.
You're on the couch forever. How do you respond? Did you make them ready for that? You didn't even think about it. Why? This is preparation of death of a loved one. Why isn't that a preparation? What am I missing here? We put them in trust. We let the children be their own trustees, and then we coach the children, depending on their marriages, how to talk to their spouses. I'm not beating on my spouses. I'm married. I'm just realistic. I think like a lawyer. That's what you hire me to do. But if there's any stress in that marriage and you didn't give them a way out, they'll feel it. well, these lawyers, they put in these complex trusts, and I'm just a trustee, and I don't really own it. Come on, pile it on me. Blame me for all of it. Give the children a talking point if they have this sort of marriage where they need one. And I can't tell you if your children are in that category, because when my kids get married, I won't know what they are in that category. We're all in the dark when it comes to that stuff. But that's about preparation for loved ones, because you're all loved ones with each other, okay? And I'm out of time, but these beneficiary trusts are wonderful. There's notifications in them, there's administrations. But again, it's like everything else in the law. It's cost benefit. Oh, if you want everything so simple, you never have to consult with a lawyer. In this complex world, sometimes you're stepping over dollars to pick up pennies. We want to protect these children. And one last point, if you create one of these trusts for your kids, and they're their own trustee, and they don't like it, all they have to do is pull it all out. Close it. They want to give it all in their spouse's name, I don't care. I create them an umbrella. If you don't want the umbrella, throw it away. Don't get on my nose. I'm just handing them out. I'm not telling you what to do with them. But most of the time, we end up on their Christmas card list. Because that's the real world. And last point, then I will shut up. Boom, goes back to that. And I don't know where it's going to go for all of this. You need to stay close to this stuff. If you need to stress test your plan. We like to have our clients meet with us at least once a year, every couple of years. You need to make sure you're up to date on this stuff, and it's doing what your plan's doing what you want it to do. Because this thing is going to continue to be a moving target. We all know we're broke, and we all know the middle class is going to face some issues here, and the rich are a small part of the top of the pyramid. So it doesn't feel right to me, because my clients are predominantly wealthy. So I'm kind of on that side of the table, and I don't like what I'm seeing. Anyway, I think I'm done. Anything else?
Yeah, I'll just give a few practical tips. These are, we'll pass that. Just after the death occurs, one thing that we want to keep in mind is the survivor always wants to come in. You would be surprised how quickly we are called. You might think, oh, we're calling children, family members. I've gotten emails in the middle of the night. I've gotten phone calls, right after a death occurs. While it's not necessary that we're the first person you see, we do want to sit down with the surviving spouse, talk about the budgets, talk about where's the income coming from. Do we need to change the portfolio? Less risk? Do we need to get the kids in as co-trustees?
And that's the stuff where, Wealth Trust is involved, and guys like Paul, they handle that stuff.
Exactly. So we're available as soon as you need us to help answer questions, to make sure you do have access to those accounts, to make sure if you got a check in the mail or you got a check from Social Security, whether you cash or what we can do with that. So we're here to sit down with you guys as soon as you need to, but we don't have to be the first person you call, but we do like to know. After you go through the process of administering your estate, you always just want to take a look at your estate plan again. Time to revisit, checking co-trustees, checking the children out, making sure the insurance is up to date, the beneficiary designations, all those things are up to date.
On first death, adding a child as a co-trustee, depending on the age of the survivor, becomes a really viable thing to do. It's time to bring your kids in, they help you manage affairs. My mother's died, my father is 87, they're going to be 87, he's not doing that well, and my sister's a co-trustee with him. So you can seamlessly manage this stuff.
And then we'll coordinate helping file final tax returns. That's part of the process we do, whether it's a death tax return, or we can help with your CPA and get the appropriate paperwork to file a final joint income tax return.
That's it.
Any questions? Okay.
Yeah, my wife and I have a revocable trust, but we also have real estate partnerships where we're the only two partners. And the partnerships are in our name, so in order to avoid probate, we gotta change those to the
Correct.
trust owning.
Yes, you would, because that'll be a probate item. It won't be on first death because you have two partners. And depending on what the document says the question is on the partnership is who gets the half of the first to die, does it all go to the survivor? And if it does, then you avoid a probate on first death, but on second death, the children are gonna have to do that, and obviously it'll be about 50, so they're stuck with probate. It's not the end of the world, again, because a probate on a part of a will can be done in 4 months. It's not expensive. So I want to leave you with, if you properly planned your estate, even if you leave larger items out of the trust, here at Colby and Thorns, we can get those done for under a couple grand in present day dollars, real simple. They're not the end of the world if you miss something, if you're otherwise planned. But make sure your out-of-state real estate's in your trust. please do that. And if you need help in that regard, we can
Well,
help.
this is commercial real estate, is out of state.
Then that's important. We need
Go
to,
with that.
we definitely need to get in the trust because you'll be going to that state and that's not gonna be cheap.
Well, you know, for sake of time, I want to invite anybody who has a question to stick around, and then we're going to let everybody go. But I would like to thank all of you for coming. We would ask if you have any comments, we would welcome them. You all have a comment card. We'd like you to leave any comments you have for us up here in this little basket on your way out. And also, if you have your email address, if you'll write that down, I will email you a PDF of this Survivor's Journal, so that you can have it in PDF format. It's a lot easier to fill out on your computer, you may find. It's easier to send to your children, your other advisors, etc. So if you want that, I'll be sending it to you. And with that, I want to thank all of you for coming. We appreciate you being here today. We have one more of these events tonight, so if you know anybody else who would benefit from coming out, we'd certainly welcome them to join us in the audience. So have a good rest of the day. Thank you.
Thank you.